Welcome to literary and jury charge practice. Let's start out with some jury charge, and the subject of this jury charge is burden of proof. Ready? Here we go. The jury has instructed that if you find Myron Boone, the treasurer, had expressed authority to sign the notes and checks and effect the loan in question, or if you find that these acts were within the apparent scope of his authority or within the scope of the authority which he was accustomed to exercise without objection by these defendants, your verdict should be for the plaintiff. But if you find that borrowing this money in the way testified to and giving this paper was not within the authority expressly given to him or within the apparent scope of the authority which he was accustomed to exercise, then your verdict should be for the defendants. And if you should find that this money borrowed or received for the paper in suit was not for the use of the defendants, and the plaintiff knew or had good cause to know that fact, or if for any other reason the plaintiff did not in good faith trust the credit of the defendants, then your verdict should be for the defendants. You are instructed that to charge a corporation upon the act of an officer or agent, it must be shown directly or presumptively either that the act was performed while in the discharge of his ordinary duty in the usual course of business and was within the general scope and apparent sphere of such duty, or that it was expressly authorized, or that it was performed with the knowledge and implied assent of the directors of the corporation or its authorized officer, or was subsequently ratified by them. In this case, the burden of proof rests upon the defendant. He admits receiving the money, and his defense in this case is that he was repaid the same. It therefore follows that the defendant must prove by the preponderance of the evidence that he has paid the indebtedness which he once owed. If you find from the preponderance of the evidence that the defendant has repaid to the plaintiff the $977.80 which he received from the check in question, then your verdict will be for the defendant, no cause of action. But if on this question you find the evidence evenly balanced or preponderating in plaintiff's favor, then you will find a verdict in plaintiff's favor for the amount you find the defendant is owing on the amount of said check. Under the evidence in this case, it appears that either all of said check has been paid or no part of it has been paid, so your verdict will be either for the amount of $977.80 or a verdict of no cause of action. If you find the plaintiff is entitled to recover, then you will add interest at 5% from and after April 1, 1958. If you find the debt has been paid, then your verdict will be a verdict of no cause of action. Back to our literary material, the article called Ruminations on Reporting, written by an attorney who comes from a court reporting family. All right, ready? Here we go. What about electronic recording in the courtroom? While it will undoubtedly still make waves and be adopted from time to time, especially in economic times where budgetary constraints cause courts to choose between salaried reporters and paying the bills for heat, light, and electricity in the courtroom, to be frank, it's a lousy substitute for the live reporter. There are two reasons for that. First, live reporters learn as they go through a hearing or trial and fix errors on the fly. Transcriptionists don't know that they're making errors, and typically have no one to ask about a strange spelling or turn of phrase. The product of even a very good transcription service is uniformly, in my view, inferior to the product of a skilled live reporter. I would submit to you that most experienced lawyers understand this. After all, trial lawyers are taught to think about the record, to be sure, not in exactly the same way that all of you worry about the record, but we focus on the record nonetheless because nothing else matters on appeal. Second, litigators don't like being told that they must tie themselves slavishly to a podium. How many trial lawyers have you seen who can really resist the temptation to pace back and forth away from the podium toward counsel table or over to the jury box and back. We're all frustrated actors, and very few of us are any good at being tied to a podium and a mic. I recently had the opportunity to try a matter for a week in the bankruptcy court. The New York lawyers on the other side quickly agreed with us to hire a live reporter to produce daily copy and to split the fee rather than rely on the transcription service typically used by the bankruptcy court. It was enlightening to see the differences between the transcripts produced by the excellent live reporters and those produced by the remote transcription service. Let me just say that I'll take a live reporter every time. Thank you. In my humble opinion, no matter how many courts make the mistake of going to electronic recording of proceedings, they eventually will never put the profession out of business, although as in every major change in the economy, they may well require that the former official reporters who made their living in that court to freelance reporting or a different career. And what about the incursion of technologies like LiveNote or other real-time transcription display technologies? To be honest, I am still not sure whether these are relevant or irrelevant technologies in my taxonomy. I can say, however, that I think that they are not the threat to the profession that some thought them to be, and that, for the most part, they have not gained widespread acceptance in the legal profession. To be sure, they have had their place and can be extremely useful in certain situations or to meet certain case demands. I dare say, however, that while all of you probably do get requests for real-time writers from time to time, the anticipated wave of demand for real-time and nothing but real-time just has not developed. In my view, it will not develop in the future. The fact of the matter is that while real-time has its uses, some of which are quite nifty, for the day in and day out bread and butter depositions, it is an annoyance. I, for one, have found that it is impossible to concentrate on a scrolling live feed from a reporter while I'm trying to stay focused on what my witness just said. Watching the testimony scroll is a distraction for me. We teach precisely that to our young lawyers, all of whom are far more tech savvy than us older lawyers. Even the young lawyers who grew up using computers, cell phones, and text messaging all at the same time don't seem to be demanding that all reporting be real time. Again, I will say this was written a few years ago, so I wouldn't say that's probably still as true. But yeah, this is an older article. All right, let's get back to some jury charge practice. And this is called, the subject of this jury charge is evaluating testimony. Ready? Here we go. Ladies and gentlemen, upon the issues here joined, the burden rests upon the plaintiff of proving all the material allegations of the complaint by a fair preponderance of the evidence. By preponderance of evidence is meant the greater weight of the evidence, the greater force with which the evidence on one side or the other appeals to your minds. But if the party having the burden in this case has satisfied you of the truth of his or her contention in that regard, he or she has sustained such issues by a fair preponderance of the evidence. If the evidence is evenly balanced for and against any particular fact and issue, then your finding upon such facts should be against the party having the burden of proof in that regard, since he or she has failed to prove the same by a fair preponderance of the evidence. If you believe from the evidence that any witness has testified falsely falsely, intending thereby to deceive or mislead you as to any material fact or facts in the case, then you have a right to disbelieve the testimony of such witness, except insofar as such testimony is corroborated by other credible testimony. This is a civil case, and you are the exclusive judges of the weight of the evidence and the credibility of the witnesses. In determining the weight you will give to the evidence of any witness, you have a right to take into consideration the demeanor of such witness on the stand, his or her candor and sincerity in testifying or the lack of the same, his or her interest or lack of interest in the outcome of the suit, his or her knowledge or lack of knowledge concerning the facts about which he or she has testified, his or her prejudice or bias, if any, is shown, his or her relationship, if any, to either party to the suit, and such other facts and circumstances disclosed by the evidence as will assist you in determining the weight you should give to the evidence in the case. Neither by these instructions nor by any words uttered or remark made by the court during the trial does or did the court intimate or mean to give or wish to be understood as giving an opinion as to what the proof is or what it is not, or what the facts are in this cause or what are not the facts therein. It is solely and exclusively for the jury to find and determine the facts, and this they must do from the evidence. Having done so, they apply to them the law as stated in these instructions. The instructions to the jury are and constitute one connected body in series, and should be so regarded and treated by the jury. That is to say, they should apply them to the facts as a whole, and not detach or separate any one instruction from any of the others. Back to our article on ruminations, my goodness, ruminations on reporting. You think I never said it before. All right, here we go. So, while embracing this technology may enhance your livelihood to the extent that you can continue to charge for it as a premium service, I don't see a situation where the failure to be a real-time reporter is likely to jeopardize your livelihood either. But it's not only technology that will make a difference to the future of the court reporting profession. I believe that continued vigorously policing of your ranks to ensure basic levels of competence is a very good thing, even though I acknowledge that it raised certain issues within the profession when first proposed. I also believe that continuing education and even periodic recertification is a positive thing and one which should be encouraged, and so ruminating on reporting from a somewhat unusual perspective, I come to my view that you reporters are not the last remnants of a dying profession, but the vanguard of a small but highly specialized and vibrant one. The challenges, as with any profession, are to continue to maintain vigorous quality control in whom you let hold themselves out as court reporters, to create, maintain, and administer an interesting and useful system of continuing education, to continue to maintain, even in the face of armies of unreasonable lawyers, your single-minded devotion to client service, to continue to embrace relevant technology as an adjunct to what you do and not as an enemy, and to grow with the needs of the legal profession and the bench as full partners in the administration of justice. When I chose to go to law school, it was in part to continue my education, but also in part because of a concern about whether the court reporting profession would be here in 2000, 2005, and 2010. I would suggest to you that the profession is in good hands, and assuming continued good stewardship will be here for many, many generations, long after we're all gone. Thank you all for the opportunity to speak with you and for listening to my ruminations. So that was a speech. Let's see. It says the following is adapted from a speech given at the Delaware Court Reporters Association Convention in June 2008. right. Get back to some jury charge. And the subject of this jury charge is interpretation of state law. Here we go. I agree that the state action was properly enjoined, and so I concur in my opinion of the court to that extent, but I dissent from the direction to the district court to hold the case while the parties repair to the state court to get an interpretation of the Louisiana statute around which this litigation turns. That procedure is advisable where private parties question the constitutionality of a state statute. An authoritative construction of the state law may avoid the constitutional issue or put it in new perspective. Under Section 1331, the federal district court has jurisdiction where the matter in controversy exceeds the jurisdictional amount and arises under the Constitution, laws, or treaties of the United States. In litigation in the federal courts under that statute, the necessity of constructing state law arises because of the federal court's duty to avoid, if possible, a federal constitutional question. Here, although potential constitutional questions may lurk in the background, this litigation primarily concerns title to land claimed by the United States. It is litigation which Congress, by sections 1345 and 1346, has entrusted to the federal district court. Those sections allow civil litigation of the United States to be conducted in the federal courts. In that situation, it is the duty of the federal court to decide all issues in the case, those turning on state law, as well as those turning on federal law. In Raymond v. Clark, a case in the federal courts by reason of diversity of citizenship, we refused to remit the parties to the state court for decision of difficult state law questions. We held that it was the duty of the federal court to decide all issues in the case, state or federal, difficult or easy. There have been exceptions to this policy, notably in bankruptcy proceedings where trustees are sometimes sent into state courts to obtain adjudications on local law questions pertinent to the administration of the bankrupt's estate. It is peculiarly inappropriate to allow that course here. Congress has decided that the United States should have the benefit of the protection of its own courts in this type of litigation. We properly hold that the federal court, not the state court, has jurisdiction of the controversy, but we beat the devil around the bush when, having taken the litigation out of the state court, we send the parties back to the state court for its construction of the Louisiana law, which is the most significant issue in the case. The problem is not only to construe the state statute, but to construe it constitutionally. The federal court can make that construction as readily as the state court. That is the congressional scheme, and we should not change it by judicial fiat. All right, we'll start some new literary material, and this is called Crack the Code to Pass the Test. Ready? Here we go. Cracking the code to tests and certifications is more than a metaphor. Expanding our vision and our goals are part of our path as keepers of the record, the historical conservator and protector of spoken words. If you are focused on changing your life, you are having internal conversations. As a tutor, coach, and CART provider, I truly believe that one can create and transform his or her goals. If you want to pass that test, it is not enough. You want to prepare with deliberate, focused intentions with conscious actions. Now is the time to prepare your stimulus plan. And now is the time to hone your conscious and unconscious thoughts, and actions to crack the code to pass your test. Recently, I received some requests on how to prepare from test takers for NCRA, California, Texas, Illinois, Wisconsin, Michigan, New York, and Arizona state examinations. I desire to gift you with tips, information to focus your internal compass. For 20 years, I have been honored to assist students and court reporters in earning their certifications. My students have been my greatest teachers. Thousands of students and reporters have accomplished huge goals, one step at a time. Sometimes someone will take only one tiny step, then there's a wobble. I firmly believe one step at a time awareness is where you find greatest progress. Even a step back is still a step. This awareness is essential to your code, your internal compass. Are you registered to take an NCRA or state test? Or maybe not yet, but soon. Are you enrolled in a court reporting program or home study? You now have an opportunity to stretch your boundaries. Stretching is good. Be gentle and remain focused on this goal, which is easier said than done. I know many students and working reporters can see and taste this lap while pedaling with an already busy schedule. Here I offer some tips to successfully crack your code. Tips I've used to coach many in your busy shoes. We will stop there and finish this up another time. That will conclude our literary and jury charge practice.